Outcome 3. Access. The oft-cited phrase, justice delayed is justice denied, has not lost its sting. The turtle-paced court proceedings have caused lingering public distrust and disenchantment with the judiciary. Internally, the administrative processes are equally slow and unreliable. Once and for all, the judiciary must deliver its services, both adjudicative and administrative, real-time when needed. Objective 1. Enhance public access to information and legal services. Access to justice has been and remains to be among the challenges faced by many Filipinos. In a survey conducted by the World Justice Project on Access to Justice in 2019, 35% of the Philippine respondents experienced a legal problem in the last 2 years, of which only 20% were able to obtain information, advice, or representation. Out of those who were able to access help, only 15% received it from a lawyer or a professional advice service, and 9% from a government legal aid office. These data indicates the breadth of the legal aid needs of the public and their access to competent legal service providers. More recent indicators demonstrate the extent of these challenges. The 2021 World Justice Project Rule of Law Index inquired into the accessibility and affordability of civil courts, including whether people are aware of available remedies, can access and afford legal advice and representation, and can access to the court system without incurring unreasonable fees, encountering unreasonable procedural hurdles, or experiencing physical or linguistic barriers. By these parameters, the Philippines scored 0.52, with 1.0 as having accessible justice and 0 as having no access. The country falls below the global average of 0.57, ranking 84th out of 139 countries in the world and 11th out of 15 countries in the East Asia and Pacific region. This objective aims to ensure greater access for all people, particularly through leveraging and the optimization of technological tools and solutions. Activity. Develop and deploy intelligent platforms for self-help services, public assistance, and public access to court-related information and services. Access to court services should not be limited to face-to-face access, especially in this time of a lingering pandemic. Free and no-expense access through electronic or digital means, including social media, will widen the reach of court services and bridge the gap in information between the public and the courts. It could also serve as the fastest and most accessible way to deliver needed instructional details to those who need it. This activity will include the launch of social media access to justice info sites with user-friendly language, easy to understand information on court services and ways to access them. For example, how and where to post bail, or the amount of filing fees for a given case and how to pay. The language employed in these sites will be English and Filipino, as well as most commonly used local dialects. In time, AI-enabled platforms for self-help and public assistance services will also be deployed. The court will put up kiosks in precincts and courts. The kiosks will assist the public as the court processes and procedures, provide answers to some of their queries, and the like. They may also be utilized in informing the public regarding the status of their cases pending before trial courts. The court will also utilize AI-enabled platforms in identifying areas of law where preventive legal literacy may be of value. Objective 2. Strengthen legal aid initiatives. The due process right to a day in court is a bedrock of effective legal representation. For most poor litigants, this makes a fair trial illusory because of the expense entailed. Legal aid should be strengthened as an equalizing mechanism. To ensure access to justice of the marginalized sectors, identities, groups, and communities, the Supreme Court tapped the significant potential of law schools to provide quality legal aid services. In 2019, the Supreme Court revised Rule 138-A of the Rules of Court, the Law Student Practice Rule, mandating the inclusion of a clinical legal education program in the law school curriculum. The revised rule requires all law schools in the country to establish at least one law clinic. Through the CLEP, the law student practitioners will be able to provide additional legal representation to communities that would otherwise not have access to legal assistance. Activities 1. Institutionalize the Clinical Legal Education Program, or CLEP, in law schools. The adoption and promulgation of the revised Law Student Practice Rule was the first step to institutionalizing CLEP in law schools. According to the revised rule, the completion of CLEP courses will be a requirement for bar examination applicants beginning in 2023. The Supreme Court, through the SC Oversight Committee for the implementation of revised Rule 138-A, will continue to develop guidance to law schools as they design and establish their CLEP and work towards the full operationalization of their law clinics. At the same time, the court will endeavor to conduct consultations and partner with law schools that have established CLEPs to provide the necessary input and recommendations on a framework to be rolled out nationally. The court, through the recommendations of the Oversight Committee, will issue necessary guidelines and policies to address concerns and direct the appropriate institutions to clarify issues. LEP for curriculum-related issues and the OCA for certification-related issues when necessary. Further, with the IBP receiving a yearly subsidy for legal aid, it should incorporate in its legal aid program the mandatory service of its members as supervising lawyers for law student practitioners under Rule 138-A. Strengthen the legal aid programs and review of the various public interest legal services, alternative legal programs, development legal aid, and other legal assistance programs of all law groups, including the IBP. Despite nationwide efforts, the harsh truth is that legal aid remains inaccessible to most marginalized sectors, with their concerns almost always falling through the cracks. In line with its constitutional mandate to ensure that legal assistance is provided to the underprivileged, the Supreme Court shall conduct a holistic evaluation of all legal aid programs in the country. It shall hold a review of various public interest legal services, alternative legal programs, developmental legal aid, and other legal assistance programs of all law groups. It shall also hold a national summit on legal assistance, which comprises of training and seminars on public interest legal assistance, alternative legal assistance, developmental legal aid, and legal aid, among others. The IBP, which receives a yearly subsidy from the judiciary, shall also strengthen its legal aid program by using the subsidy to require the mandatory service of its members as supervising lawyers for law student practitioners under Rule 138-A to be assigned on the basis of IBP chapter membership in the areas where law student clinics operate, and set up and allow free computer use with internet access in their chapter offices for their members who need the same. 3. Conduct a national summit on clinical legal education of 2022 with the Philippine Judicial Academy, or PhilJA, and the Legal Education Board, or LEP, and the Philippine Association of Law Schools, or PALS. This summit will be in furtherance of the Legal Education Summit in 2019. The summit will discuss experiences on the implementation of the revised Law Student Practice Rule, further recommendations for clinical legal education, but also showcase the learnings and best practices under the revised Rule 138-A by law schools, legal aid providers, and other key stakeholders. 4. Database of free legal aid providers composed of law clinics and IBP chapters to be posted on the Supreme Court website and other platforms of the judiciary, IBP, LEP, and PALS. Information is a key preliminary step to securing access to justice. This activity will provide timely, relevant, and appropriate information to the public online about the various free legal aid providers across the nation and where and how they could be contacted. For starters, there will be efforts to map legal aid services. With the use of the map, the areas or communities without legal aid services will be determined. The map will also provide the public with information on where to access the nearest legal aid service. 5. Review and retool the Enhanced Justice on Wheels, or EJOW program. The Enhanced Justice on Wheels program, or EJOW, was conceived as a way of providing greater physical judicial access to rural communities. In light of the increasing number of courts and the evolving use of digital technologies, this program will be reassessed to improve its objectives. 6. Evaluate the impact of access and impact of judicial processes and services on marginalized identities, groups, and communities. While it has always been committed to providing relief to the marginalized, the Supreme Court concedes that much needs to be done. As such, it shall press forward and explore other avenues to improve access to its services. The court shall identify and conduct various immersions in key areas where access must be improved. From the information gathered firsthand, it shall make the proper evaluation of the pressing challenges and effect the necessary changes. Objective 3. Strengthen the foundations of Sharia justice. Of the 56 Sharia courts, 5 district courts, and 51 circuit courts, only 27 courts are organized and operational, with the Sharia district courts having an end-year caseload of 154 cases in December 2020, whereas the Sharia circuit courts have a caseload of 408 cases in the same period. In the exercise of the supervisory powers of the Supreme Court over the Sharia courts and in support of the Bangsamoro justice system, the Supreme Court will constitute a committee on Sharia justice to pursue an integrated effort to institute reforms and initiatives that will contribute to the facilitation of justice and the rule of law in the Bangsamoro Autonomous Region in Muslim Mindanao, or BARMM. This will be done within the country's institutional, constitutional, and legal framework. Activities. 1. Constitution of Committee on Sharia and conduct of institutional review and assessment of the Sharia justice system. To strengthen the Sharia justice system, there is a need to assess its institutional framework, including the internal capacities within a broader historical, cultural, and ideological contexts, as well as within the context of the current BARMM governance framework. A deeper probe into the impact of these on the current Islamic notions of justice and current formal and informal dispute resolution norms and practices should likewise be conducted. The objectives of these study are as follows. 1. Conduct a review of the overall performance of the Sharia justice system. 2. Identify the strengths and weaknesses in the various aspects of the Sharia justice system that promote or hinder their efficiency or effectiveness. 3. Examine the societal and cultural contexts and identify the opportunities and threats that affect the functioning of a sound Sharia justice system. 4. Assess the administrative structure and operating systems context in the judiciary in which the Sharia courts operate. 5. Define the implications for strengthening the Sharia justice system and identify the appropriate comprehensive and long-term reform directions. A physical help desk per court station may also be established to respond to queries from lawyers and litigants on Sharia court-related information and services. 2. Evidence-based study on the expansion of the mandate of Sharia courts. To generate data to inform policy and decision-making with respect to myriad issues and challenges confronting the Sharia justice system, particularly with respect to Article 10 of the Bangsamoro Organic Law, or BOL, the following studies will be conducted. 1. Study on the creation of additional Sharia courts outside the BARMM and the implications on the current Sharia courts within the BARMM. 2. Expanding the jurisdiction of Sharia courts to include both criminal and commercial cases. The committee shall endeavor to assess the applicability of the different punishments under Sharia law for graver offenses that may be considered inconsistent with the rights enshrined in the Constitution. 3. Feasibility study on the formal organization of the Sharia High Court created under Article 10, Section 7 of the Republic Act No. 11054. 3. Study on strengthening the Sharia legal education system. This study will involve an overall assessment to strengthen the Sharia legal education system, both academic and continuing education, and will include the following. 1. Qualifications for appointment to Sharia district and circuit courts and eligibility to practice before Sharia courts. 2. Strengthening of the Philippine Judicial Academy's training program for Sharia lawyers, judges, and court personnel. 3. Institution of bar reforms on Sharia. 4. Review of the Sharia rules of court. To guide judges and practitioners in Sharia court practice under the BOL, there is a need to review and update the current Sharia rules of court. Objective 4. Gender fairness and inclusivity. For genuine access to justice to thrive, court services must be inclusive and non-discriminatory. Judicial proceedings and court processes, both adjudicative and administrative, must be free from political, racial, cultural, religious, and society-ingrained practices and beliefs that are gender discriminatory and insensitive. Access to justice must be equal for all in every aspect. Activities. 1. Adopt guidelines for the use of gender-fair language in the judiciary and gender-fair courtroom etiquette. The judiciary will, for the first time, adapt its own organic rules, institutionalizing the use of gender-fair language in all its courts and offices and in all work-related issuances. Complementary rules on gender-fair courtroom etiquette will also be mainstreamed to provide guidance to all justices, judges, and court personnel on the observance of respect, sensitivity, and inclusivity for all gender identities and expressions in all court proceedings, including court-issued decisions, resolutions, orders, and other papers. 2. Conduct gender sensitivity and inclusivity, reorientation, and application workshops for judiciary officers and court officials and personnel, care of CGRJ with PhilJA. With the passage of new legislation relevant to gender-based issues, like the Safe Spaces Act, reorientation of the justices, judges, and court officials and personnel on gender sensitivity and inclusivity is needed to raise their consciousness and inform their decisions and actions. For full utility, the reorientation should be coupled with application workshops that will simulate real-life gender-based challenges encountered in and by the courts or even abated by the courts. The court may tap organizations such as the Urduha Women's Desk of the Ateneo Human Rights Center that offer trainings for in-house trainers, especially in terms of gender sensitivity. Three, issuance of guidelines for victim-sensitive courts. Special laws and rules have been adopted specifically for the protection of women and children. These notwithstanding, in cases where women and children are the victims of criminal acts, There are meager safeguards in place to prevent the re-victimization, principally through insensitive and prejudiced court proceedings and processes and court actions. Sufficient data caution against practices that exacerbate the trauma of these victims. The guidelines will be studiously balanced against the equally well recognized rights of an accused in a criminal prosecution. 4. Commission a study on gender representation and mobility in the Philippine judiciary. Compared to judiciaries across the region, courts in the Philippines appear to have a higher level of gender participation. Nevertheless, there appears to be a stark difference between the appointments of female judges at the lower courts versus the higher courts, especially the Supreme Court. This empirical study on gender participation and mobility in the Philippine judicial hierarchy from 2006 to 2020 will look at gender disaggregated data collected by the Philippine judiciary from this period and examine the annual proportion of females appointed as judges in the municipal and metropolitan trial courts, regional trial courts, the Court of Appeals, the Court of Tax Appeals, the Sandigan Bayan, and the Supreme Court. It will explore patterns of female appointments to the judiciary for almost 15 years and across court levels and identify possible bottlenecks or barriers for female representation. It will also explore possible displays of gender preferences in appointments to the Supreme Court. The study will contribute to related literature on female participation in high courts and its effect on judicial decision-making. 5. Launching a first story, Gender Award of Distinction. The results of the study that was commissioned by the Asia Foundation with respect to the gender diversity and mobility in the Philippine judiciary show how women judges face struggles and challenges in terms of appointment to and advancement in the judicial hierarchy. It also identified some factors which create an impact on the disproportion of gender distribution within the different court levels, highlighting the encouraging increase in diversity in trial courts, which, however, is not reflected in the collegiate courts, particularly the Supreme Court. With the launching of First Story, Gender Award of Distinction, the Supreme Court, through its Committee on Gender Responsiveness in the Judiciary, or CGRJ, shall give due credit and recognition to the exceptional skill set and peculiar experiences of women in the judiciary who have risen above gender-related challenges. 6. Commission a study on feminism in the judiciary. Patriarchy and masculinist norms heavily influence Philippine legal structures and demonstrate their effects on the material conditions of women, including those who do not conform to heteronorms. There is a need to understand how the justice system reinforces dominant gendered and masculinist norms in Philippine society. There is also a need to identify problems at the intersection of sexuality and law to develop reforms and policies to correct gender injustice. The Court, in AM number 22-02-28-SC, approved a study which will look into the Court's interpretation of gender-responsive laws and its capacity to point out gender-responsive remedies. The awareness of gender biases, gender inequalities, and discrimination as they manifest in decisions. Example, stereotyping men and women, gender-based violence, and to pronounce corrective statements or measures to overcome the biases, inequalities, and discriminations. The results will hopefully inform the judiciary regarding future steps towards gender mainstreaming.